The pistol brace rule is dead. Struck down, vacated nationwide. Case closed, right? Wrong. Because the same government that lost in court just openly admitted they can still come after your braced pistol anyway. No rule needed. And until about 72 hours ago, almost nobody was pushing back on it. But now, United States senators just sent a letter directly to the ATF. And the language in that letter is not polite. This is the update every brace owner in America needs to hear right now. Let's go back to the beginning, fast. The Biden administration pushed through a rule claiming that most pistol braces turned your firearm into a short-barreled rifle under the National Firearms Act. Overnight, millions of law-abiding gun owners became potential felons over a piece of equipment the ATF itself had previously approved for years. Gun owners fought back hard. Lawsuits were filed across the country, and eventually a federal judge struck that rule down entirely, nationwide. Then the Trump DOJ took over, dropped the government's appeal, and confirmed the rule was gone for good. Most of the remaining lawsuits were dismissed. The ATF acknowledged the rule no longer existed. Most people exhaled. They thought it was over. It wasn't. Here's the part that should make every gun owner stop and pay attention. After the rule was struck down, the DOJ filed a response in one of the last remaining brace cases, a lawsuit brought by Gun Owners of America and the state of Texas. And inside that filing, buried in legal language, was an admission that changes everything. The DOJ said, and this is their words, that even with the brace rule completely gone, they are still enforcing NFA and GCA restrictions against certain braced pistols. First, the ATF must publicly state that it will stop enforcing this legal theory against braced pistols entirely. Second, the agency must issue formal written guidance confirming that braced pistols are not short-barreled rifles. And third, the ATF must enter a binding legal agreement in the GOA court case that permanently locks in that position. That third demand is the critical one, because a press release can be walked back, a policy memo can be reversed, but a binding court agreement, that follows the agency no matter who is running it. The senators also went after the constitutional argument directly. They pointed to Heller and Bruin. They argued that braced pistols are widely owned, commonly used for lawful purposes, and fully protected under the Second Amendment. They made the case that braces actually improve safety and accuracy, and that there is no legitimate public safety justification for treating them as regulated NFA items. And they reminded the ATF of something important. Millions of Americans bought these firearms legally. They followed the guidance the ATF itself provided for decades. And then one administration reversed course and tried to turn those same people into criminals. The senators are saying clearly, the Trump ATF should not carry that legacy forward. So right now there are three separate forces colliding on this one issue at the same time. The DOJ is in federal court preserving their legal authority to enforce brace restrictions without a rule. The White House budget recently signaled a policy preference to move away from aggressive enforcement. And now members of Congress are demanding a binding legal commitment, not a promise, not a policy shift, but a court-enforced agreement that shuts this down permanently. Three forces, pulling in slightly different directions, and one federal court sitting right in the middle of all of it. That is exactly why the GOA case cannot be dismissed or ignored. It is the one legal vehicle that could actually resolve this permanently. A favorable ruling there doesn't depend on who wins the next election. It doesn't depend on who the next ATF director is. It locks the door legally and throws away the key. Here's the bottom line for every brace owner watching this right now. The rule being gone is not the same as being protected. The DOJ has made that crystal clear in their own filings. Until a court draws a permanent legal line, or the ATF enters a binding agreement, the underlying threat remains exactly where it was.